Good evening to everybody, to the Advanced Private International students. Karibu sana. And read what I posted on the screen. Anyone can unmute and read. Anyone can unmute and read what I posted on the screen. I believe that there is a problem of your internet, it seems. Yes, Habariza Zioni, students of the Advanced Private International Law, Conflict of Laws, Thoughts in the Private International Law. Professor Dr. Mohammed Saheb Hussain, Professor of Law, School of Law, St. Augustine University of Tanzania, Mwanza, Tanzania, East Africa. So without wasting the time, let me come to the point. Yes, at least I could see your microphone now. Okay, read what I posted on the screen. At least now, unmute and read. Unmute and read what I posted on the screen.
Conflict in law of tort and the private international law.
Good. Okay, let me come to the point. And this article is written by Adarsh Singh Thakur. I should be indebted to him. He's a third-year student, Indoor Institute of Law, and he discussed the concept of foreign tort and its various aspects. So I tapped him. That's why I would like to say thanks to him because I have to acknowledge him. So now introduction is, every country has its own laws which are made to regulate the conduct of the people who live in such countries. Yes. For example, in India or Tanzania, the law which governs the Indian citizens, and for the Tanzania, the law governs the Tanzanian citizens, and thus laws of other countries like that of England or China or any will not be binding on Indians, and such laws can only be referred when there is a question of law on which the Indian is silent. At that time, sometimes when the municipal law is silent, for instance, Tanzania law is silent, at that instance, we will try to rely on the other statutes which are in advanced, or the country which are in advanced, that statute that we will take into consideration. So that was the point which I want to share. Next point is, usually, whenever a tort is committed, the plaintiff files a suit in the court for the claiming damages or other remedies for his loss against the defendant. But a question arises, what will happen if a tort is committed by a person in a foreign country? Will such a person be bound by the law of the country where such tort is committed? Or will the law of his country apply to him? For instance, if a Tanzanian committed a tort in Uganda, and whether the Uganda law would be applicable over there where the tort is committed, or Tanzanian law would be applicable over there, and which will be the applicable law, lex causa there. What is our connecting factor for the tort? Dorcas, what is the connecting factor for the tort?
Lex causa.
Lex loci delicti, where the tort is committed. That is the connecting factor for the tort. So usually, that such an instance would be there, and which law could be applied? That is the question. Where such a tort is committed, or will the law of the own country where he is a citizen of the country? Because I told you, a Tanzanian committed a tort in Uganda. So tort committed his place is Uganda. Can the Uganda law would be applicable, or the Tanzanian law would be applicable? Suppose if a case is filed, because in the conflict of laws, forum convenience will be given, because Tanzanian doesn't have the house there in Uganda, but he went over there on the business trip or any other trip. At that time, he is having the house in Tanzania and the business also Tanzania. And if he files a case in Tanzania, at that instance, can the Tanzanian court will give the judgment? At that instance, can that the judgment would be enforced and recognized by the Uganda or not? Even though there is no reciprocal in nature, even though it is not in the 11 countries Uganda, but a theory of obligation would be there. Suppose if they don't regard the Tanzanian decision, if a Ugandan committed a tort in Tanzania, at that instance, if the Ugandan file a case in the Uganda, at the time, the Uganda government has given, the court has given any judgment, at the time, the Tanzania will not accept the decision of the Uganda, because Uganda did not accept the decision or the foreign decision or foreign judgment of the Tanzania at the time the Uganda. And that is the reason, if you give the respect to me, I will give the respect to you. And there is that comity theory would be there. If I don't give the respect to my judgment, and naturally your judgment will not be respected over there. Overall, what they want is, if he is really made a breach, naturally, yes, that would be implemented as it is. The decision of the Tanzanian will be implemented as it is in Uganda. For instance, and the Uganda government, Ugandan law is giving a less amount, but the Tanzanian law is giving the more amount in the tort. At that instance, if a Tanzania law would be applied over there for the decision, and the decision will be taken, and the judgment is given by the Tanzania, yes, it will be what I say, recognized and executed in Uganda, because the choice is given over there. Even a substantial law can be other law where the lex causa is there, because he filed a case in the lex forum, that is in Tanzania, because he is having the house in Tanzania, but the tort committed in other place. Of course, whether he committed a tort or a tort is committed to him in the Uganda, and whichever is there. If a tort is committed in the Uganda by a Ugandan, and the injured party is a Tanzanian, and he cannot file a case in the Uganda, and he came to the Tanzania, and he filed a case in the Tanzania, at the time, if the decision given by the Tanzania, the decision would be, the judgment will be recognized and enforced in the Uganda, because it is a obligation, a theory of the obligation would be there. The next time, if any Ugandan got injured by the Tanzanian, at that instance, yes, if the Uganda government court has given the decision will be respected by the Tanzania, because they respected the decision of the Tanzania there in the Uganda. So that is the reciprocal in nature, or the theory of obligation will come into the picture. Read the illustration. Read the illustration. Unmute and read.
A, who is an Indian, visits Bhutan, and there he commits a tort against B, who is a citizen of Bhutan. Here, the tort committed by A is a foreign tort.
And the injuries? And the injured is a Bhutan citizen. Are you following me?
Yes, God.
But why you did not give the reply? Sir, I don't know what is Bhutan. Bhutan is a country. Tibet is a country. Nepal is a country. Like here, the Pembeni countries are, Uganda is a country. Nairobi, Kenya is a country. Zambia is a country. Burundi is a country. Is it clear?
Yes, God.
Now, can the Bhutani file a case in the Bhutan, and the Bhutan judgment would be applicable in Indian court? Answer is, if Indian court decision is respected by the Bhutan, at that instance, definitely Bhutan judgment will be respected by the India. Is it clear?
Yes.
Okay. In India, the law of tort is not codified. White India, in Tanzania also law of tort is not codified, because both are the common law countries. As a result, there is no statute or an act of legislation which prescribes the unlawful acts and the punishment for the same. Thus, the Indian courts have to apply the principle of tort law on the basis of the English case law. In the similarly, Tanzania court will apply the tort law based on the English law, case law, from which the law of tort in India or the Tanzania find its origin. What is the origin of the law of tort in Tanzania?
India.
Of course, Indian law of evidence, Indian criminal procedure code, and other things will be there. But India is taken from the England. Are you following me?
Yes.
At the time, you should say that the tort law which is there in Tanzania, it is nothing but the tort law of the England and the tort law of India. Is it clear?
It is clear.
Also, due to the lack of awareness among the Indian people about their various rights and the long amount of time and which is taken in the courts for deciding the case, the same is applicable for the Tanzanian people. For the among the Tanzanian people about their various rights at the long amount of the time which is taken in the court for deciding a case. Do you think that a common man in the Tanzania would have a knowledge that he can file a case if somebody hurt him? Yes. Answer.
Could you repeat?
Please repeat the question.
Any Tanzanian and who is from village, he got hurt or accident by another person. At that instance, can that person having the knowledge that he can file a case in the court of law? Kijijim too. I'm speaking.
No, he doesn't. No.
No.
Because he doesn't have
No,
his rights. And that is the reason the cases will not be filed. Suppose if he is educated and having the awareness and somebody has given the lesson to him or teach him or say him, yes, you do have a right to file a case and help him to file a case, at the time only he can do so. So the same applicable either India or in Tanzania. So in India, in the same manner in the Tanzania, principle of law of torts have not developed as much as the English law of torts. But now people are getting the awareness. Now they are not keeping quiet. If any train comes late also, they can file a case in the court of law. If any plane is delayed over there, definitely they can have the right to file in the court of law. If a bus or any other transport will not reach to in time where he got suffered and his employment chance is diminished because he did not face the interview at the time because of the delay, yes, he can file a case. The now everybody having the awareness, yes, we should not keep quiet because we do have such a right, yes, we can make it out. And such rights are nothing but is a human right as well as the rights given by the constitution or the rights given by the local statutes. So Indian courts or Tanzanian courts, they follow the decisions of the tort decision based on the either Indian law or English law. So, thus the concept of the foreign torts in India is also on the same foreign as that of the English law of tort. In the same manner, the Tanzania tort of law also based on the torts committed in the torts made clear in the India as well as the torts made clear in the England. That so and so thing is said to be the one of the offense. A foreign tort can be defined as when a tort which is committed abroad by a person and therefore the cause of action for the tort arises abroad. A tort committed in the abroad is said to be a foreign tort. Like a foreign judgment, when you can say foreign judgment, give me the answer. Foreign judgment, give me the answer. A judgment given by the. Yes, give me the answer.
Please repeat the question.
What is foreign judgment?
It is a judgment which was decided by another jurisdiction.
Say other foreign country.
Yes, other foreign country.
Because jurisdiction means Mwanza having a jurisdiction and Dar es Salaam having the jurisdiction. A foreign jurisdiction, abroad, a foreign court. So foreign tort is
A tort committed abroad.
a tort committed in the Mwanza. Is it?
No,
Then where it is committed? A tort committed in the Zanzibar.
no,
Then where it is committed?
Kenya, Uganda.
A tort committed other than the Tanzania.
Yes.
Answer is in that way you have to give. Namely, Uganda, Kenya, Burundi, or any other country, foreign country. So thus foreign torts are committed in a foreign nations. There are two kinds of the foreign torts which are as follows. Number one, tort of reality. Whenever any tort is committed against the property which is situated in a foreign country, the tort is called tort of reality. It is for the property. In such a torts, the affected property is an immobile property, which means that such property is fixed at one place and cannot be moved from its position. And hence, what is the connecting factor for the immobile property?
Lex loci situs.
Not loci, lex situs. Lex situs.
Yes, Professor. Lex situs.
Yes, under the English law of torts, no action can arise in case where any tort relating to the immobile property is committed, and thus in such a case the suit filed by the plaintiff is rejected by the court. But now, because of the relationship of one country to another country, because of the globalization and the liberalization, because of the charters, because of the treaty, because of the doctrine of obligation, they are going to respect, even though the tort is committed in a different country, and that to be the immobile property. Now let us see that how. Generally, it will not be rejected, because if they reject it, at that instance, they also reject it. Suppose foreigner property there in other country. Can a foreigner keep the property in Tanzania? Answer. For instance, me from India, can I buy a property and maintain a property in Tanzania?
Movable properties, but not immovable.
So movable property, I can enjoy it. But I cannot buy the nyumba, a house, on my name. Is it? Say,
Yes, Prof, you can't.
okay. That means if I want to invest, I can invest in the form of industry. At the time, they could give the license. Is it or not?
Yes, Prof.
Okay. Now let us see that how. And illustration.
It is.
Okay. Illustration is A is a resident of England. Okay. And who visits India on a business trip. And while staying in India, he commits a tort of trespass on B's house. And B's house is in India. Who committed A? A is a resident and a citizen of England. And he went to India for what? Business trip. And what he did? He made a trespass. On whose house? B's house. Where is the B's house? In India. Here, even though a tort has been committed, but since it has been committed against an immobile property, which is situated in a foreign country, it is a tort of reality, and such case against A will not be maintainable. They say it's not maintainable, but let me see in the further what is there, how way it is not maintainable. Because he committed a tort. If he really committed a tort, even for the immovable property also, then he should be tried. Okay, one thing is there, because he's the subject of England. Okay, a notice will be given to the foreign, that is, what is that? A ambassador or high commissioner, that your subject, means your countryman, has committed a trespass to the immovable property here. Hence, an action should be taken against your citizen. The answer, definitely they will give the permission, because one cannot come to the another country and make a trespass to the land or any offense committed against the immovable property, because the law says that for the immovable property one cannot file a case. No, they can. Let us see that in further what it says. In case of the Britain, Britain South Africa Company, Britain South Africa Company versus Company RD Macambik 1953, apparent court 602 page. The defendant was resident of England, okay, and he had trespassed into the mine of the plaintiff, which was situated in South Africa. Yes, the mine is a immovable property. As a result, the plaintiff brought a suit against him in the court for trespass. It was held that since the tort was committed against an immovable property in a foreign land, the suit is plaintiff cannot be successful. Therefore, the defendant was not held guilty. Trespass, okay, that there is no just a much injury. Suppose if he has taken the gold from the gold mine from the South Africa, at the time that it becomes a movable property. Which one becomes a movable property? Gold. Can't he try it as a theft? Answer is yes. Are you following me?
Yes.
See,
Yes,
merely he
Prof.
trespassed means, okay, with knowledge or without knowledge, he entered into somebody's house. And that is the amount of the actionable per se. Is a trespass, no doubt at all. And trespass is a criminal offense. If it is to the land, it is a movable property, that is a offense towards the property. If it is the body, it is offense towards the human being, like a battery or assault. But if he has taken something from the house, then he committed a tort against the movable property. Can't he be tried? Answer is yes. But they say exemption only. If he made a trespass, okay, a action cannot be taken over there as an excuse. Suppose if he committed a daily kilesiku trespass, what will happen? Can you take an action against that person? Kilesiku. Every day. Answer is yes. We can take an action. If made once, okay, it's excused because it's a foreign element. But kilesiku, every day that he could make it out, then he's having the bad intention of something. Then he can be tried in the criminal court by following the domestic law of the India, if it is committed in India. Is it clear?
Yes, Prof.
Merely trespass, it will not be tried over there. But if he has stolen something from the place, the stolen property is a movable property. At that instant, definitely he can be tried. No doubt at all. So that is the first one they said, no, tort of reality means immovable property. Now let us see the personal torts. If foreign torts, whenever there is an unlawful act committed against a person or against the movable property, such tort is known as a personal tort. Here, person, like assault, battery, false imprisonment, or a movable property, like a theft, taking away, trespass to property, The tort is known as personal torts. Unlike a tort of the reality, in case of the personal tort, the person who suffers a loss has a right to file the suit against the tortfeasor. As such a person's suit is not rejected by the court. Is it clear now? For merely for the trespass of the immovable property, he will be exempted. But he has chosen something, taken something from that place, then it becomes a personal tort, either to the person or to the movable property. Then he can be tried in the court where he committed such an offense. Is it clear?
Yes, Prof.
So, thus, for the movable property and the body, personal torts are applied and remedies available to the injured person. Illustration. Read the illustration. Anyone can unmute and read this illustration.
A resident of Spain, is on a trip to Switzerland and got his phone stolen by B. Here, since the phone is a movable property, such a tort will fall in the category of personal torts under foreign torts, and the suit filed by A will be accepted by the court and B will be held liable.
Yes, B would be liable because he has stolen the property of
A.
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 Yes, and A is a foreigner because he is a resident of Spain, and the stolen property stolen is where? Switzerland. Where is Switzerland? Where is Switzerland? Sema.
Europe, sir?
Is it in France? Is it in Germany? Or Switzerland is a separate country? It is a separate country.
It's a separate
It's
country.
a separate country, sir.
It is a separate country. What is the headquarters of the Switzerland? Let me see. Switzerland. Because people keep the money in the Swiss bank. All black money. Switzerland capital is Bern. In practice, however, with the presence of the parliament, the government, and foreign embassy, Bern is a well and truly the capital of Switzerland. You know, Swiss bank is the Geneva is the
Yes.
capital of Switzerland. Geneva is the second most populous city in Switzerland after Zurich, and is the most populous city of the Romandie, situated where the Robine exists Lake Geneva. It is the capital to the Republic and canton of Geneva. The municipality has a population of it. So Swiss bank people need to keep their money, and that they will not leak it how much money would be there in the Swiss bank. So now the question comes over here is, yes, a trip to Switzerland, if it's committed over there by the B, who is the resident of the Switzerland, an action will be taken against the B. And which law would be applicable? Which law would be applicable? Spain law is applicable or Switzerland applicable?
Switzerland.
Because action taken place in Switzerland, lex loci delicti, where the dereliction was taken, an offense is taken, a tort is committed. So illustration another is K, a resident of China, while on an internship program in Singapore, was assaulted by B. Assaulted by B means injured is who is injured? Who is injured?
K was injured by B.
B. And K is the resident of China. And B is
Resident of Singapore.
resident of Singapore. That means two countries are involved. Is it or not?
It is.
then it is a true conflict of law. So here, since the tort was committed against the body of K, it will be personal tort, and the suit filed by K will accepted by the court and B will be held liable. That means K can file a case where?
Singapore.
Singapore. And the Singapore law would be applied over there, and B is wrongdoer, tortfeasor, and B has to compensate as per the law of the Singapore to the injured K. So personal torts are separate from the torts of reality, because while in the tort of the reality, there is no right to file a claim against the wrongdoer, under personal tort, a person can file a suit for the injury or loss caused by the tortfeasor. Is it clear?
Yes.
But in all the suits under the personal torts cannot be accepted by the courts, and therefore only on the fulfillment of certain conditions, a suit for the personal tort which has been committed abroad can be accepted by the court. There are certain conditions are there where it cannot be accepted. And let us see that what are the conditions. The conditions are as follows. Number one, the wrongful act is actionable in the country where such a wrong has been committed. Suppose a wrongful action is actionable in the country where such a wrong has been committed. And for instance, there is no adultery in Tanzania. Is it true? Is it true? Seman, there is no offense of prostitution in Tanzania. Is it true? Give me the answer. Or say pass on. Or say don't know. Don't be silent.
I don't know.
Even myself also doubtful. But people do the prostitution here. And I don't think that they will be caught out. But in India, they say, yes, prostitution is a business. A recent Supreme Court decision. A police cannot manhandle the prostitutes. They will treat them with the dignity, and they will be taken shelter. The government is going to give the license to them to be a profession for the prostitution. Instead of hiding and making, better make the open. If anybody wants, and if he wants, he can go. Sir, what about the Ukumvi? Yes, there will be medical tests will be done to them from time to time, and a certificate will be issued to them that she will not have the Ukumvi, or the HIV/AIDS, or any sexually transmitted diseases. But anyway, but I am against the idea of that license given to the prostitution, because it becomes a open market, and there is a much and hue and crow. Even a person doesn't have the knowledge about the sex, also he will learn the knowledge by going over there. Okay, let us come to the point here. If tort is committed in such a manner, and how it would be there. The first condition which has to fulfill the case of the personal tort to be the successful in the tortious act which is committed by the defendant against the body or the property of the plaintiff actionable in the country in which this action has been committed. Prostitution is not a now offense in India. For example, if a tort is committed against a body and he files a claim for the damages, the court will first see whether such suit can be filed in the court of the country where such an act was committed or not. Lex causa. If such an action is not actionable, then suit filed by the A will be rejected. In case, now if anybody file a case on the prostitution in India, that case that can be rejected now, because prostitution is a profession, it is not an offense now. Is it clear? Say, is it
Yes,
clear?
Prof. It is clear, Prof. It is clear.
Yes. Now, it is a very, very interesting landmark case law. Phillips versus Air, one case law, and Phillips versus G and General Motor Company Limited. These are remarkable case laws are there too. Okay, let us see the Phillips and Eyre, what the case law says. It is 1870 Queensman's case law. The plaintiff had filed a suit against the defendant, who was the governor of Jamaica. You know where is Jamaica? Jamaica is a country and the capital is Kingston. Why the Jamaica is famous? Law of the sea. And there is a special institution there, if I not be mistaken, law of the sea. Jamaica, Kingston. So a governor of Jamaica is who? Defendant. And who filed a case? The plaintiff had filed a suit against the defendant, and who was the governor of Jamaica, because the defendant had falsely imprisoned him. Who imprisoned him? Defendant means who here?
The governor of Jamaica.
Governor of Jamaica is the defendant here, because the plaintiff had filed a case, because plaintiff is imprisoned over there with a falsely. The defendant contended that, means the Jamaican, the defendant contended that he had done this in pursuance of the act of the Jamaican legislation. Whatever the Jamaica legislation say, yes, with the legislation that I made you to imprisonment in order to suppress the rebellion. I made it because you are creating a nuisance over there for that rebellion. With the act of the Jamaican that I suppressed you, I imprisoned you. And it said the governor of Jamaica, to whom? The plaintiff, and who filed a case. Okay, in this pursuance of the act of Jamaican legislature in order to suppress the rebellion, I did it so. Good. It was held that since such an act was not actionable in Jamaica, the place where the act was committed, therefore a suit filed by the plaintiff could not be accepted, and thus the defendant was not held liable. Because the Jamaican government will say, the legislation say, if any person committing a rebellion or unruly mob or any fuss or any riot, at that instance, governor is having every right to imprison such a person, because the cause of action had in the Jamaica. As per the Jamaica law, yes, he can be imprisoned. At that instance, the plaintiff case is rejected. So the suit filed by the plaintiff could not be accepted, and thus the defendant was not held liable. Phillips versus Eyre, it is a remarkable case law. As I told you, Phillips versus G&M, General Motor Company Limited. Who will what the General Motor Company manufactures? General and Motors Company, what it manufactures?
Cars.
Motor vehicle.
Yes, please tell me.
Cars.
Brand name is?
GMC.
Okay,
GMC.
that is one car. Next.
Chevrolet.
Chevrolet is there, because in our case Chevrolet comes. A Chevrolet, it is okay. We will come across that case law. It's a very interesting case law. I will tell you when it comes over there, case law, and you can also Google it and you can read the case law. Let we have the debate on it. Phillips, same spelling, Phillips. Phillips versus G&M, General Motors Company Limited, Automobile Company Limited, because the headquarter is somewhere. Where is the headquarter of this G&B company? Headquarter?
America.
No, I say America, no doubt, but the state. Okay, let us see.
Yeah, I have no idea.
Yeah, because there are 3 countries involved over there. 3 countries are involved over there. He purchased it in one country, and the manufacturer is in different country, and the accident happened in a different country. At the time, the people got injured, and they filed a case. At that instance, which country law would be applicable? Because there are 3 countries are involved. We will see it. That is an interesting case law. You also read it. Okay, now coming to the point, here is, in the above case, it was observed that the suit was wrongful act cannot be enforced only if such an act is not actionable in the country because of no recognition being provided for such a right. But if there is any limitation placed of an act from being actionable only on the ground on the procedure, then such act can be actionable. Suppose only procedural aspect it is acceptable, but the substantial base it is not acceptable. At the time that case will be tried. The same thing it is saying here. But if there is any limitation placed on an act, limitation comes under the substantial law or procedural law. I repeat the question. Limitation comes under the substantial law or the procedural law.
Under the procedural law.
Substantial.
But in some countries, they took it in a substantial law. But Tanzania will not take it. Even in the India cannot take it as a substantial law. It is a procedural law only. So if there is any limitation placed on an act from being actionable only on the ground of the procedure, then such an act is actionable. A procedural act, we cannot consider it, and hence we can entertain such a case. Illustration. Read this one. Illustration. Read this illustration.
If A is wrongfully detained in another country and he would not have filed the case in the court because of the limitation period being over, in that situation, the case can be accepted by the court of A's country because the act was not actionable only on procedural grounds.
Is it clear now? If it is limitation period is over, still we can file a case in the country because the country from where he hails, there is a limitation. He allows it. If A is wrongfully detained in another country and he could not have filed the case in their court because of the limitation period is being over there, because the limitation period is say about 3 months. But in Tanzania, it is a 6 months. Let me presume it. In that situation, the case can be accepted by the court of A's country because the act was not actionable only procedural grounds. He can also say that, sir, it is a procedural ground and hence it cannot be rejected. If it is a substantial point, yes, it can be rejected. Even though Tanzania limitation period is less or more when you compare with the other country where the limitation period is, the case is rejected. Now the question comes over there. Limitation will bar for the remedy, but not for the right. Did you get my point? I repeat. Limitation will bar the remedy. Bar means hinder. Bar the remedy, but not the right. Suppose somebody you are a due, say about like 2 lakhs to somebody else, and there are 6 years are passed, and bardo 10 years also passed, and your friend who loaned you 2 lakhs, he cannot go to the court, but you are supposed to pay him, though not in the court, in the next court of the God. Are you following me?
Yes, sir.
Please repeat.
Yes.
You are due. Really you are due. And that fellow did not file a case because you say bardo, 10 years are over. But still, he cannot go to the court, but you are due in the court of God. In the same manner, suppose that person who has given the loan is a foreign man, say Kenyan, given the loan. At the time, the bar will not be a hindrance. The court will accept it because if you see the natural justice, yes, the Kenyan is the loser and he is the beneficiary. Am I right? Am I right?
Yes, sir.
See, everybody knows that he is a due. Only the limitation period is barred. With that, we cannot reject his claim. So the Tanzanian court will accept the case and entertain the case, and the judgment will be given based on the evidence produced over there. Is it clear?
Yes, Prof.
That is the same
Yes,
thing
sir.
which is here, which I highlighted, the example which is given, which you read, the same thing. The example which you read now, which we highlighted, it is give the same thing. Limitation period is being over. In that situation, the case can be accepted by the court A's country because the act was not actionable only on procedural ground. But substantial ground is there. Yes, he is due. So at any time it can be stopped, but we can see in Care versus Francis Times and Company 1902, Appellant Court, Appeal Code 7 and 60, following the proclamation of the Sultan of Muscat, the defendant has seized the goods which were being carried on a British ship, and thus in the suit filed by the plaintiff, it was held that the act could not make the defendant liable because in the country where it had been done, such an act was not actionable. The country where it is done, such action, that act is not actionable at the time, you are not going to get any remedy from that. Refer the Phillips versus Ayer case law. Refer the Phillips versus Ayer case law, where in the country which is not actionable, you cannot claim such a claim in that country. Is it clear? Is it clear?
Yes, Prof.
Yes.
The same Phillips versus Ayer case law, we can use it here. Because it is a proclamation of the Sultan of the Muscat has given, then the defendant has seized the goods which have been carried on the British ship. Thus, in the suit filed by the plaintiff, it was held that the act could not make the defendant liable because it is a order from the Sultan in that country, yet it can be seized over there. In that country where it had been done, such an act was not actionable because that is allowed. And the plaintiff could not get any compensation because that is not actionable in the place where it is seized. So, one more important rule under such a suit is that when a cause of action is not of a local nature, then suit is allowed by the courts. Yes, that is another thing, but we'll stop it today because we'll see tomorrow the point, the Mustin versus Fabregas case law that we'll see tomorrow. Yes, anything to be asked, you can ask me now. Because we cover the matrimonial issues, now we are covering the tort issues, then I will cover after some time the contract, then some issues of the property. We will see it, then that is the malisa of the course. And I don't think that, I believe that your examination timetable has come.
Yes.
Yes. Yes, Prof.
From which date
The,
your
the,
exam
the,
starts? From which date your
The
exam
timetable
starts?
the timetable states 4th of July.
Then what would be the last working day? Instruction day, Fundisha day.
I'm not aware of that. I'll ask. I'm not aware of that.
Is it not almanac is given? Can the class will be the one day before the examination also?
No, no, Prof.
How many days gap would be there?
I don't know, but I'll inform you, Prof, because I do not know.
Yes, because if we can go pole pole. If the time is more, we can discuss more. Is it clear?
Yes, Prof.
Yes, please find it out and we'll do it. Then we'll make it out. Now, the disturbance is coming from your side, and now I will stop it. Goodbye. Have a good day, and